Productions at GCTV are sponsored in part by Bay State Health, providing the care you and your family need when you need it close to home. Visit them online at baystatehealth.org. Greenfield Savings Bank. Visit them at 400 Main Street in Greenfield. Call them at 774-3191 or go online to greenfieldsavings.com. Greenfield Community College, providing access and excellence in higher education in the Pioneer Valley. Visit them at gcc.mass.edu. The Hammond Family. The Hammond family are longtime supporters of Greenfield Community Television. New Fortune Chinese Restaurant on the Mohawk Trail in Greenfield. Visit them online at newfortunema.com. Call them at 772-0838 and check them out on Facebook. Real Cleaning Services, cleaning Hampshire and Franklin County since 1972. We don't cut corners, we clean them. Check them out online at realclean.com. Call them at 413-422-1143. People's United Bank, located at 45 Federal Street in Greenfield. You can call them at 774-3713 or visit them online at peoples.com. The Solar Store of Greenfield, replacing fossil fuels and nuclear power one home at a time. Visit them at 23 Fisk Ave. Call them at 413-772-3122 or visit them online at solarstoreofgreenfield.com. Thank you to our sponsors for supporting all of GCTV's productions.
We are welcoming Buz Eisenberg from GCC here to talk about the First Amendment. So without further ado, I'm not the person you came here to hear. He is. Here's Buz.
Good morning.
Good morning.
Just by way of clarification, I'm no longer with GCC. I know, I'm a retiree, like a few other people.
And you still have a suit on?
I'm a lawyer.
Ah.
I have to look the part or else people won't want to pay me our outrageous prices. Yeah, so a suit, I probably don't need it this morning. But I dress the part, dress the role, right? But I am an attorney, and I was asked to speak on behalf of the New England First Amendment Coalition, which puts on programs statewide like this and asks people who are advocates for the First Amendment to do presentations like this. So Justin Silverman, the executive director, asked me if I would be available this morning. I said, I'd love to speak in Greenfield at the library. Oh, congratulations, Lisa, on the grant.
Thank you.
It's huge news. Congratulations, Greenfield. Sunset. And so I actually did prepare a thesis for this morning to share with you my view of the current status of the jurisprudence and national attitudes about our First Amendment. I think I actually over-prepared, but that's okay. I'll winnow it down as I go. And in preparing, and just sort of, I'm not going to burden you with much history, except for this. Today is July 26th. Bear with me. It was 230 years ago to the day this afternoon, when in Poughkeepsie, New York, our neighboring state became the 11th state to ratify the United States Constitution. Now, that should get a yawn out of you, except for the following. Of the 13 colonies, upon ratification of the Constitution, a former colony became a state once 9 of the 13 colonies had ratified. The first one was Delaware on December 7th of 1787. A few months later, in February, Massachusetts became, I think, the 5th. And then in June, we had our 9th ratify it, and then the United States was born. 9 states of the 13 colonies had ratified. And then New York became the last of the 11 to ratify the original Constitution on today, July 26, 230 years ago, 1788. The 2 holdouts were North Carolina and Rhode Island. And that's why this is of interest to us in speaking about the First Amendment. I'm going to just backtrack and then I'll explain why that's of importance. here was the big debate. Our framers had huge arguments about three separate entities that were at issue. We had been tyrannized by a British rule, by a monarch who, by divine right, could make law, could just make a proclamation off with his head because he stole the cabbage today. And
I have a loyalist hat on today.
you do, you have a loyalist hat on. All right, off with his head for having a loyalist. But that unbridled discretion that comes with being granted divine right to rule and make law was exactly what we rebelled against in our Declaration and our Articles of Confederation, etc. So what the debate was, which should be the strongest? A strong federal government, the union of the various states, is that the sovereign? Or is each of the 13 colonies, is each of those states to become the sovereign? Obviously slavery was kind of a big issue here. We can run our own economy if we want to use free labor. Who was Massachusetts to tell Virginia what to do, et cetera, et cetera. Or is it the individual whose rights were impaired by British rule, who had to quarter British soldiers and pay unfair tariffs, et cetera, et cetera. And that was the fight that was going on in the First and Second Continental Congresses, is whether which of these three blocks of interest should prevail. The Federalist view, the non-Federalist pro-state as the local sovereign, or the revered individual. North Carolina and Rhode Island said, we're not going to ratify that stinking Constitution unless it has some individual rights in it. But the first 7 articles of the Constitution without amendments, only draws up, because of that battle, because they couldn't agree, it only draws the architecture of the new government. Article 1 says there shall be a legislature, it shall be bicameral with a House and a Senate, it shall make the laws. You know, the Madisonian model. Article 2, there'll be an executive branch. It will implement and enforce the laws that are made by Article 1 legislature, right? It's going to enforce the laws, implement the laws. Article 3, there shall be a judiciary which will interpret the laws to see whether Congress has a right under the Constitution to do the law that it passed, or whether the executive has the right to enforce it the way it did. That's the judicial branch. And then the other 4 articles that deal with everything from how to ratify the Constitution or amend the Constitution to whether there's civil rights to civil actions in court, etc. Those 7 articles just drew up the architecture of a government. They didn't discuss whether an individual has a right to free speech or free religion, or whether the state takes priority over the federal government. They decided to just agree not to agree for now. But those 2 states, North Carolina, interestingly, a slave state, Rhode Island, which was formerly next to the Massachusetts, part of the Massachusetts Bay Colony, they said, we're not going to sign that Constitution until we have individual rights discussed. So, a process began even before the Constitution was ratified by June of 1788, talking about, okay, what kind of rights will we embody in the Constitution by amending it, its first amendments. And the very first amendment laid out barriers for the government to not intrude on the individual in 4 arenas of rights. The first, of course, because of why the Mayflower came here, right? It's religion, 2 parts. 1, an establishment clause. Government may not establish a religion like Iran is a theocracy, right? And then a free exercise clause. You can't stop me from exercising my religion. And then, of course, free speech, which we now call free expression, because it's not just what I say, but it's an expression in the government, or an armband, or something else that I'm wearing. And then, of course, assembly, the right for us to get together and express our grievances to our government without having soldiers come and separate us. And finally, the right of a free press, which is essential to inform the people of what's going on. Kind of timely, don't you think? All of these issues. So, all of that is by way of a setup. I just set you up for what my thesis is right now, because that was And when I was at GCC and when I was teaching civil liberties, that's what we talked about. For religion, you looked at all those cases from the very first religion cases that talk about, we know that City Hall in Greenfield can't put a crucifix at the top of City Hall. That would violate the Establishment Clause. But can it put a creche on the town-owned common, right? Or we know that you can't keep me from speaking about my political view, but if I go down at 3 o'clock in the morning on your residential street and use a megaphone and say, vote for me, can government regulate that? Well, that's my speech. You can't regulate that. There's time, place, and manner restrictions that are allowed under the law over the last 230 years, and we've kind of fiddled with them to figure out what kinds of time, place, and manner restrictions government may regulate that imposes on your otherwise protected speech rights, right? And the same is true with the press. If it's the Pentagon Papers and the Nixon administration wants to stop the New York Times and the Washington Post from publishing them, it's called prior restraint in the law, it's called censorship. To most of us, stop it before it gets published. For librarians, it's kind of a big deal, right? Well, when can it, government, do that? Has been refined. These are the usual questions that we come up with and we dabble with. I'm here, however, to report on what I think is a chilling development. The debate has changed and shifted, and no more so than in the last 5 years, certainly since Citizens United. Who doesn't know what Citizens United is? Please, be honest. Okay. Since Citizens United, where it was deemed a free speech issue, whether or not a corporation or a group of people can say, they can spend any amount of money with a super PAC to publish whatever they want about their view of the world, their ideological preferences or concerns, and whether that can be regulated by a federal election or other commission of the government on First Amendment grounds, on First Amendment free speech grounds. The court said government is going beyond the power that it ought to have, just like the framers said they were afraid of it doing, right? That sort of has shifted, bringing us the conversation from those traditional crash in a town common kind of questions, can a town do that without violating the Establishment Clause, to what was recently described as 1 month ago, today, by Justice Elena Kagan as weaponizing the First Amendment. And that's really what I'm here to talk about, is weaponizing the First Amendment. And I'm going to use as examples 4 cases you've probably heard of that just ended this past session a month ago. It ended, I think, June 28th or 26th, but basically 1 month ago. The Supreme Court ended its session, and it ended with a powerhouse of a case called Janus versus American Federation. I see some nods here. So here's what Janus is. Well, GCC. I have some. So those of us who worked at GCC in the faculty, there is a statewide union that represents community college and other public higher education teachers. And that statewide union, almost all of us, well, all of us paid agency fees to maintain the union so it could collectively bargain with the state over the terms and conditions and pay for teachers statewide, right? One bargaining unit, state dealt with that bargaining unit for all the community colleges and all the public education institutions, and everybody has to pay a fee if you want to work at GCC of whatever it is, dues, $400 or $500 a year taken out of your pay to maintain the union. And some, not many, faculty members said, I don't want to join the union, I don't even believe in unionization, I'd rather not be a member, but I still have to pay. So back in 1977, I went up to the Supreme Court in public sectors, police, fire, teachers, higher education, AFSCME, trash collectors. Unions are allowed to charge that agency fee whether you want to belong to it or not, because you're going to benefit from what they negotiate. You're still going to take the higher pay, the better hours, the better sick pay, etc. That was the issue in 1977. It was settled, and it just came again when a state worker named Janus, Mark Janus, said, I don't want to pay. I said, well, no, he didn't want to pay that agency fee. And he said on First Amendment grounds, it violates his free speech rights to not allow him to express his belief that he shouldn't have to join a union that he doesn't want to join. And it went up to the Supreme Court, and in a very sharp majority opinion, Justice Alito wrote on the very last day of the session that as a matter of free speech, the First Amendment is violated by allowing unions to charge an agency fee to somebody who doesn't want to join the union. And yet, the union negotiates the contract. You can't negotiate an individual contract with GCC. You're bound by the union contract. You just don't have to pay the fee. So effectively, a lot of pro-union people, myself included by way of disclosure, believe this effectively is another, back in the 30s, at the end of the 30s, I think that 39% of all workers belong to a union in the United States. Now it's down to 6.5%. This might bring it down to 2 or 3%. Public sector employees, this is going to effectively make it impossible for unions to have headquarters that they can pay for, et cetera, if people elect not to join this. So that's a use of the First Amendment that is, analytically, I don't expect you to be able to, without reading it, process it, but I just want to read a little bit from Justice Kagan. Justice Kagan, if you don't know, Elena Kagan was, actually I had a case against Elena Kagan, and she had when I went to the Supreme Court, they ruled against even taking it 5-3. She had to recuse herself because, but big deal for me, she was my adversary in this case. We fought over the phone for hours, and so I thought I was Mr. Big when she was named to the Supreme Court, and she had to recuse herself from this case. But she is probably, if not the least ideological, one of the courts, certainly of the 4 liberal members, she's the one who's most centrist, and she's always cautious with her language, but she let it rip on this case. And what she said is, she used this word weaponizing. Now, weaponizing is a word that in political circles has become sort of vogue. It sort of means you turn something normal and harmless into an implement of combat, intellectual, by weaponizing something. And she said the majority, it does so by weaponizing the First Amendment in a way that unleashes judges, now and in the future, to intervene in economic and regulatory policy that it should be only Congress's to make, or the administrations to regulate. Now, today is not the first time the court has used the First Amendment in such an aggressive way, but this court is becoming a habit, and it threatens not to be the last time the court does it. They talk about speech. Speech is everywhere. Speech is a part of every human activity. It's part of our employment and our healthcare and security trainings, and you name it, and all of those require regulation, reasonable regulation. And if we're going to always say government can't regulate just because speech is involved, then that means almost all economic and regulatory policy is going to be affecting or touching speech, and therefore is going to be discredited by this majority. So this majority's road is running much longer than this case. And at every stop on this road are black-robed rulers overriding policy choices which were made by the citizens' representatives. It's ironic because the majority does not like legislating from the bench, but what it's doing is squashing legislation from the bench. Really powerful. And the author of the majority opinion, who's Justice Alito, said, unfortunately, the dissent, what's he say, sees the need to resort to bare accusations. So these two are spitting at each other in a really virulent, uncharacteristic, it's not the normal genteel disagreement that the court usually engages in. This is a real ideological fight over the use of everybody's good friend, the First Amendment. Because in this country, it doesn't matter where you land on the right-left continuum, everybody reveres the First Amendment, the right to an opinion, the right to speech. But here, I'm suggesting that Justice Kagan is right, that we are weaponizing the First Amendment, to use it in ways that are outside the parameters of what should be the discussion about government regulation of the individual's rights. Let's look at another case. Let's look the day before. Masterpiece Cake Shop versus Colorado Civil Rights Commission. So in Masterpiece Cake Shop, you might have heard of this. This was just, if that case was June 26th, I think this was June 25th of last month, last day before the session ended. And in Cake Shop, the justices tried to decide if Colorado's public accommodations law violated the First Amendment religious of a cake maker. Let's back up. You've heard this language of public accommodation, have you? Mm-hmm. We lawyers, that's why we get paid so much. We use big words that mystify you. But it's not a big deal. Here's the deal. It's the 50s, and Woolworths has a lunch counter that's a place of public accommodation. They invite the public to come and buy a hot dog and sit down at the lunch bin, right? We don't want blacks. We don't like blacks, all right? So the court had to grapple with this whole stuff, and it all came out of Brown versus Board of Education, all those civil rights, beautiful civil rights cases, and here's what the court said. If Peter and Carol don't like me because I'm Jewish, they don't have to invite me into their house. I can't say you must let me in. It's a constitutional infringement not to let me in your private house. You can say, I'm sorry, we don't like Jews. Get away from our front door. But if your house, if you run a hotel and you say you can't stay in our hotel because you're Jewish, that's a place of public accommodation where public is licensees and invitees to come in. Now you're in trouble because we passed a Civil Rights Act that says you can't do that. You can do it for your private poker game, Peter, but you can't do it when you invite me to stay over and pay money. You have to let me in because religion is a protected status, right? Protected class, as is race, as is gender, and in Colorado, like Massachusetts, as is sexual orientation. This Colorado baker said, my religion says that homosexuality is evil. I believe religiously that I shouldn't be making a cake for that wedding. And so the Colorado Civil Rights Commission said, wait a minute, we have a Civil Rights Act that includes sexual orientation along with race and religion and gender, right? And so you must make a cake for a gay couple because it says so in our Colorado law. And so the baker said, I don't like that, and took it all the way to the Supreme Court. And the Supreme Court said, under the First Amendment religious freedom, the Colorado Civil Rights Commission has interfered with the right of this baker to say, I don't want to serve those people. You're interfering with my religious freedom. And I contend, borrowing from Justice Kagan, that is weaponizing the First Amendment to allow for that particular set of prejudices to surmount the right of someone to go to a place of public accommodation and be accommodated in getting their cake made for their wedding, right? So that case, Masterpiece Cake Shop, was another one where, in this case, Justice Kennedy wrote the opinion, and he actually, the case is horrific, except it stops short of horrific. Because what they've done is they've invalidated what the way that the Civil Rights Commission handled it and sent it back down. Instead of declarative, what they're going to do hasn't been done yet. But what they've done is said that the Civil Rights Commission showed a definite bias, or actually prejudice, against this man's beliefs in the way they conducted hearings on whether or not he should be cited under the Civil Rights Act in Colorado. So they sent it back down for new hearings to Colorado, ostensibly because the commission screwed up. But I think we know where they're going to land on this thing. There are, taking longer than I wanted. There are other cases that were just decided, like the redistricting cases from Wisconsin and Maryland, respectively. Democrats and Republicans, respectively, challenged redistricting. You know what that is, when there's a census and then legislative districts are drawn, and Texas championed this in the 90s when Dick Armey managed to get these crazy, squiggly, amoeba-like district shapes in order to make sure that there were as few Hispanic and Black majority districts as possible, taking lumps of Blacks and Hispanics and putting them in as minorities in districts that were predominantly white in order to ensure that Republicans won the legislative seats in both in Texas and in the federal sense. So that was being challenged by this court. And even though the court sent it back down for reasons because of standing issue, whether the claimants had the right to go before the court, so they sent it back down to a 3-judge panel. Basically, they're using the First Amendment political belief language to justify redistricting in what I consider to be unconstitutionally exclusionary, dangerously anti-democratic way. The First Amendment has been weaponized now, so that anything that can arguably be said to violate somebody's religious belief, I hate bald people. God told me to hate bald people. I'm being ridiculous, but is all of a sudden your religious freedom rises to the level where reasonable government regulation, which is what we've been doing for 230 years in order to ensure that the majority can prosper, that the majority can advance, that we find even in times when we're motivated by racism, that we can enact legislation to have us all grow together and protect people against unfair discrimination. Those things that happen in the Warren Court, are being undone by this court. And so that's my concern, that's my thesis about weaponizing this beautiful set of concepts. And I will shut up and take comments and questions. And why don't you say your name before you...
Hi, I'm Elizabeth Foster.
Hi.
I'm the Sunderland, just here visiting. I wonder whether or not this further threatens a law like the legalization of gay marriage. Can this offense be extrapolated or extended into law that's protecting groups like that?
It's a really interesting question, and if anybody else wants to answer or speak to any of these questions, I'll give a shot, right? First of all, when I talked about Janus, the union case, the public sector union case, unseating an exactly the same fact pattern from 1977, we call that stare decisis. It's a rule of precedent that basically what we'll hear when Judge Kavanaugh's hearings before the Senate Judiciary Committee for his confirmation, whether he's confirmed as a nominee to the president for the Supreme Court, we're going to hear him talk about stare decisis. Will he accept precedent? And of course, people who are pro-choice are going to be talking about Roe versus Wade as a precedent, and that's going to be the huge gorilla in the room, right? So when Justice Kennedy was the fifth of a new 5-member majority, 5-4, in affirming the right to gay marriage, and here in Massachusetts in 2003, the Goodrich case is under our state constitution, but federally, what they've done now is they've shown that they are willing to undo something that was decided before. So here, it's always an issue whether or not, now sometimes that was good, because Brown versus Board of Education undid the 1890s case of Plessy v. Ferguson, which said separate but equal is okay, right? So sometimes we want the court to undo something, depends on where we land on this spectrum, right? But I think right now the answer is probably we're safe, because there's just too many people who believe in gay marriage who are out. They're not closeted like they were 40 years ago, and the case that Lawrence versus Texas, which said it's illegal. It's only 2003. 13 states still there were criminal sanctions for engaging in homosexual activity in your own home. In Lawrence versus Texas, 2003, right? Not so long ago. Lawrence versus Texas undid a case called Bowers versus Hardwick, which was from 1986, right? So 17 years later, a lot of the same justices said we were wrong then. It is unconstitutional to criminalize private, consenting, adult humans. They were very careful. You can't do bestiality, Justice Scalia, and you can't do it in the public town common. It has to be in the privacy of your own home and by consenting adult humans, and then it's okay. But I think in the wake of that, and Kennedy is now leaving, but I can't imagine undoing something that's as recent as that. That would surprise me. But good question. It is scary. In no particular order. Yes, sir.
Rich Ross.
Hi, Rich.
Basic understanding of the First Amendment, the other amendments. It says Congress.
Yes.
How does that apply to state rules, which is everything you've been referencing?
It's a great question. That's a really long answer, but here's what happened. You might recall that in the 1860s we fought a great civil war. And at the end of it, at that point we had 12 amendments. The 13th Amendment was passed in 1865, and it said, you can't own people. Right? Now we've gotten everybody together, it's Reconstruction, we have these representatives from these vanquished states, and they all voted, you can no longer own people or have indentured servitude. And then, what we keep hearing about even today, the 14th Amendment passed. And when we think of the 14th Amendment, we think of anyone born in the United States as a citizen thereof, saying that these people that we brought from Africa, their children were born here, they're now citizens, unless they were women. Right? But the citizens of the United States, but what we don't think of a lot, unless you're a lawyer or work in this field, is that part of the 14th Amendment that in the 5th Amendment, it said people shall not be deprived of life, liberty, or property without due process of law. And that, because it was the 5th Amendment, only applied to the federal government, Congress. But in the 14th Amendment, it said, and no state shall deprive anyone of life, liberty, and property without due process of law, and equal protection under the law. So the Equal Protection Clause is applied to the state. And then we went through a 100-year-old period, which is still going on, of what we call selective incorporation of the Bill of Rights to the states. So some things we've said don't apply, like the requirement of a grand jury to indict somebody for a capital offense in the 5th Amendment. That only applies to the federal government. Massachusetts has a grand jury. California doesn't have to, in a famous case. But the right to a jury, if you're tried for a crime, that's a fundamental right, and that's applied to the states. So Congress has now been interpreted as government. So it means Greenfield. It means the sewer district of Greenfield.
So any government.
Any governmental entity, as long as the right we're talking about has been selectively incorporated by the law.
Particular right.
Yeah, so there are some things. So Greenfield, I mean, it's always, these are the issues that always come up. Does the town of Greenfield have a right to make me shovel my sidewalk when it snows? Right?
Sure
And
does. Yes.
Claims to.
Claims to, yeah.
Of course.
so, yes ma'am, I'll get to you.
In thinking about weaponizing the establishment of religion, part of the First Amendment, I'm curious, could that then be turned against some of the other, freedom, abridging speech or press or right of assembly?
Yeah, great question. I mean, Hobby Lobby. Anybody not know what Hobby Lobby is? All right. So there, under the Affordable Care Act, Obamacare, women's right to reproductive health care was guaranteed, but because all insurance policies had to include that as part of the coverage, right? And so Hobby Lobby challenged that and said, well, we're a closely held corporation, a family corporation, and we don't, even though we employ tens of thousands of people, we don't want to provide that coverage because we hate birth control, because if God wanted you to have birth control, he would have, men would have been born with condoms on or something, I don't know what. But, and the Supreme Court agreed 5-4, saying that it was an abridgment of religious freedom. So your question is a great one, because let's create a religion. Right now, you and I are in jail, and we belong to the steak and wine religion. God wants us to have nothing but filet mignon and nice fine Bordeaux at dinner. And if the federal government doesn't provide us with those, then it's violating our right to religion. And let's do this.
And lobster.
Or
Well,
whatever.
except I'm a vegetarian, so we're gonna.
Oh
But
no!
I'm with you on the one.
You have been excommunicated. But it is true. Look, no, I'm sorry. I don't say. I hate when people say "look" because it's like instructive. And but this scheme was created to protect our beliefs. We have a right to believe in it. He could be looking at me right now and thinking, I believe this man should be dead, right? But once his belief turns into action, the government may want to regulate that behavior, right? What's the difference between a firmly held religious belief? I think people should be allowed to be gay because I think God wants people to be diverse and blah, blah. And a political belief. I think people should be allowed to be gay because government shouldn't interfere with people's lifestyle choices. Or, and you can marry assembly and speech, you can marry religion and assembly, you can, and press, and so all of these rights, I mean, we have a bundle of rights. Some of them are fundamental rights, like these. And some of them are just sort of preferred rights that government decided, what we call Malum Prohibitum, like we want to dedicate some parking spaces as handicapped, requiring a shield because we believe that it's better. It's not as fundamental a right as the right to speak or practice your religion. It's just we decided it's a good idea. Our representatives decided that's a good idea to do. You're going to find that some people who believe in that might elevate that to a level that's much higher than somebody who says it's not as important as a religious right or an atheist, right? I mean, so there's always going to be the flow that you're talking about, and there's always going to be a debate, an important debate. If what we're trying to do is have government regulate things in order for the most of us to have the best shot at having a good life, liberty, and pursuit of happiness as possible, then I think you'll end up with a more sort of compassionate overview that says, I want government to regulate that, or I don't want the government to do that, right? So it really depends on what your ideological motivation is. I'm here to contend by weaponizing the First Amendment. The court is following an ideological course. It's using the law, it's using the First Amendment to rationalize its view and to enact, as if it were a legislature, its view that government should allow people to pour as much money they want into a campaign, or not have to support unionization because unions cost more money for the public entity, or. That's my thesis, that's my way of disclosure, that's my belief. Right. Chris?
You started.
Is this okay? We doing all right?
So you started this outlining the difference and the conflict maybe between federal government, state government, individual rights.
Right.
And I think so many of these cases stem from, you didn't mention a corporation in there. And so many of these, what's a corporation? Where does it fit? Should it have rights? Should it not have rights? And in my opinion, a lot of these cases decided one way or the other are wrong because they either usually they give corporations a right that, this doesn't say corporations shall make no rule, it says Congress shall make no law. So, how, I think when the Constitution was written, most businesses were sole proprietorships and individual rights and corporate rights were close to the same. But now we've got, Walmart and things that, have all these employees and affect things in a way. Because I'm not offended by a baker or a sole proprietor saying, I'm not going to do that. I'm not offended. It's
I'm not going to serve you, you're black.
Right. I think that's fine if he's a sole proprietor. I personally would not get my birthday cake there if I knew that.
Mm-hmm.
And I don't think the government should patronize that. But if he decides that he makes more money by putting the sign in the window, I'm okay.
You can't eat at my restaurant, you're black.
I think that's okay.
Okay. As
As long as I can't, like I said, I'm not going to eat there if I see that sign in the store, even though he would welcome my business. But anyway, that's kind of a side thing that's fun to talk about. It's just the idea of you started with individual rights, state and federal power.
Sure.
And corporations aren't anywhere in that deciding, but so many of these cases tend to be, is Hobby Lobby, does Hobby Lobby have a right, or is it just compensation? You practice your religion, you've given me as part of my compensation healthcare, and I get to use that, you know, that's not part of your religion, that's part of my healthcare.
Right.
And like I said,
So you think our living constitution, by deferring to corporations in the way that it hasn't really kept up with the current need of where to regulate more actively? which is
right, because corporations have so much more power. To me, in the 18th century, the biggest threat to power or to individual liberty was the king, right? The government infringing and arbitrarily doing these things. In the 21st century, the biggest effect on my individual freedoms now seems to be, what does a big corporation do?
I'm going to divert for just, that was a comment, not a question, but I'm just going to
Well,
give you
it's
my-
just where, how do we, you
Let me just
didn't
round
mention
that out.
corporations.
Let me round it out
Yeah.
with just a little bit more history. Here's what happened. In the 15th century, especially in the 16th century, what happened is this phenomenon called the Dutch trading companies. So what happened is, you and you and you and you, we got together and we said, we're part of a new emerging mercantile class. We're at the intersection of feudalism, which was, you know, by birthright, right, primogeniture and all that stuff. But this noble class started to, during the Renaissance, started to emerge, and we had a mercantile class, and so they got together and they created trading companies, and they found out, especially the Dutch and later the Portuguese, whoa, you know what's really lucrative? Go kidnap some blacks from Africa, you could sell them for a lot of money, right? And then the New World became a new market for that, and the rest is our sordid history, right? So, but those Dutch trading companies led to the, you and I could go, I could be a partnership, or we could be a partnership. And we could be a general partnership, we each own 50%. You could be a silent partner. You give me the money and I put in the elbow grease, right? Now you're called a limited partner, right? And then eventually what they figured out is, but wait a minute, you are then responsible if I screw up on her. If she has a cause of action against me, you're responsible for it. So let's indemnify you by creating something called a corporation, right? Now we could all put in our money, buying stock shares, right? And then we all own it together, but we're only limited to our investment. If I get sued, if it gets sued, I still keep my house and my fortune. I'm only limited in my exposure to whatever the value of my stocks are, right? And we'll hire people to be our executive director who can be personally sued for screwing up something, right? But the corporation won't be, right? So that notion was a way to spur investment, and it was alive and well in the 18th century, and very florid and very powerful. And our railroads were built by it, and the industrial age was fueled by it, and those corporations, which we all hate so much, I'm not defending them, I'm just saying,
Right.
to be accurate,
Mhm.
been going on for about 400 years.
Yeah, well.
That these sort of affiliations among people, these trading companies became the way that we did business and the way that sort of, because it's nature of capitalism, that's what spurred the economy. Blah, 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 buzz. Yes, sir, then yes, ma'am. Let's say our name.
Jim Geisman.
Hi, Jim.
Hi. Citizens United had to simplify it, it said corporations are people.
Yes.
So then
They enjoy the same rights as people.
they enjoy the same rights as people, and they have the same responsibilities of people, and if a corporation is killing somebody, then they should be prosecuted under the law as a person.
Wow, can somebody give him a robe?
You
I
know,
wish they said that.
I raise that for a variety of reasons. I mean, first of all, I mean, the shoe will be on the other foot, so you better be careful about your cobbling. And that's for redistricting, that's for making laws, and that's for policy. And I think, you know, that's totally ignored. But coming back to Citizens United, it seems to me that you ought to be able to sue corporations as people, and you throw them in jail, which means they're out of business, completely out of business. And why hasn't that come up?
Well, it does come up in very, very rare. You're absolutely right. I'll give you a couple of examples. Enron, you might remember, the way that, not going into Enron too much, there were 386 holding companies that were used to shield the financial peril. And it was just a house of cards. It was a, what do you call it? Mirror, a room of mirrors or something that
A Ponzi scheme.
it was sort of a Ponzi scheme, but what they had is they created 386 holding companies
It's all
and
off the books.
all across, right, so that the debt that they was buried in these holding companies so that they looked like they were flush by $8 billion or whatever it was. So what happened is their accounting firm, one of the big 7 or 8, Arthur B. Anderson, created that, what is it? It's not a mirror, it's a
Illusion?
illusion, thank you,
Yeah.
that illusion that they actually were not in horrific debt, which eventually caused the collapse and the loss of 200,000 people's retirement and all the nightmare. Arthur B. Anderson was found criminally responsible, but they didn't go to jail. The company was found criminally responsible, they paid a big fine, thank you very much, and went on being one of the big 7 accounting firms. We very rarely see it, and it's always in the area of inchoate crimes, we call them, or conspiracy crimes, or joint enterprises that will find a corporation to be responsible. But, I mean, sometimes, in the case of Enron, Kenneth Lay and Jeffrey,
Skilling.
thank you,
Went to jail, didn't
they went to jail, and I think Kenneth Lay committed suicide, but they were Enron principals.
he
They
had a
weren't-
heart attack.
Had a heart attack. Whatever. You guys should be up here talking, not me, but that's the point. On rare occasions, we'll hold a corporation responsible for a really obviously criminal intent. And that's not to even scratch the surface of environmental degradation or workplace hazards or kinds of things that really are, you knew that's what was gonna happen to somebody and you did it anyway kind of thing,
Yeah.
pharmaceuticals and, you know, I totally agree with you, Jim. I think it's a really good point. I think I had this young lady over.
Hi, Jessica Osen.
I just,
Hi. I brought my 12-year-old middle schooler
thank you
with
for
me.
coming. Have I bored you terribly? No? You're following all this? God, I wish I was you when I was 12.
She's pretty smart. She's a pretty smart kid, and we've talked about the First Amendment recently in our house a few times.
Yay.
And I thought, well, why don't we go check this out? And we've had encounters with it in our life too. You might remember we did the board that the mayor wanted to take down.
I represented you
So,
guys.
yeah, so we've run in that in our family. But I was thinking something more like at the middle school, there's this gay straight alliance group, you know, and they want to hang a bulletin board with the bisexual flag and the rainbow flag and all this. And
Which
this,
middle school here in Greenfield?
well, no, they did that. But
Oh,
then
they did that.
so this next question is just theoretical.
Okay.
So then if a Christian fellowship in that school decided they wanted to post flyers with some scripture that pointed to the evils of homosexuality, let's say, like I think this is like a scenario that could relate to her and to me. How would that go down? Because one has a religious argument and one does not. And is that a way that they might weaponize or use the First Amendment to say, well, the Christian fellowship, I mean, they're based on religion, where the Gay Student Alliance is not. And how might that be different if there was like a Southern Pride group who wanted to put up the Confederate flag?
Really interesting, and you had that issue in Greenfield too.
Yeah.
Jessica's daughter, what's your name?
Marina.
Marina, hi. What do you think? Should a what do they call the spiritual group?
Well, it's like Christian fellowship. I made
Christian
it up. I don't think
fellowship.
they have one, but
Should they be able to put up signs that promote their view of the world, which is homosexuality is bad, in a publicly owned school? Is that a violation of their free speech rights to say no? You know what? I'm gonna narrow down the question a little bit. Scenario number one. It's clearly, it says this is only the opinion of the Christian Fellowship Group and not the opinion of the school, versus scenario number two, it doesn't say that. Would that change your opinion?
I think so, yeah.
How would it change your opinion?
Well, if it's saying that it's just, you know, Christian Fellowship's opinion and they're not trying to like impose it on other people, I feel like they have a right to do that. But if they don't, I feel like it's not.
I think I agree with you. I think that's pretty perfect. I don't want to silence somebody's opinion as long as we all understand that that's their opinion and it's not the school's official opinion, because that's what an institution of learning is about. It's a place to kick around ideas. Some of them might be good, some of them might be bad, but we don't want to silence ideas in an institution of learning. We want people to be able to express their views, and for you, Marina, to be able to go up and say, I disagree with you. God doesn't hate homosexuals. My God does, or whatever. So that's where I would land on it. Now, if they didn't clearly say that this was the opinion of a person, an entity, a group, right? Then I think we might have a problem because the Establishment Clause doesn't want a town, even though it says Congress, or a state-owned entity, state-financed entity, to be expressing religious viewpoints in that way. That would be unconstitutional in violation of the Establishment Clause because we separate church and state. So Jessica's question, what you've been talking about is a great thing, but it's by way of disclosure. You have to disclose to people.
So that would be
Yeah.
similar, we also talked about universities inviting controversial speakers, that's been in the news plenty.
Exactly. I always hate that. I mean,
Right.
we just had this where right now I'm spending most of my time, we created the ACLU of Massachusetts Immigrant Protection Project, and we're representing hundreds of immigrants that are being grabbed by ICE. I hate ICE. But ICE and the Department of Justice at AIC, American International College, had this forum. And I went there, and the Pioneer Valley Workers Center sent people there to, remember this, to keep them from speaking. Well, it was sponsored on an academic, they were answering questions, like I am right now. They had a panel of ICE people and Department of Justice people who were interacting with the audience, and these people shouted them down. Now, I'm a big fan of the Pioneer Valley Workers Center, and I'm a big opponent of ICE, but in a school, I want to hear. I want to be able to hear what they say. I want to be able to challenge them and ask questions. I want to be able to understand what they contend is the way to look at the world, because that's what schools are for. That's the beauty of schools, even if it's something especially if it's something you disagree with, right? So you guys are great for having that conversation. Thank you, Mon, for having
Yeah, thank you.
Yes, ma'am.
Just sort of a follow-up to this, I'm having a hard time kind of honing this into a narrow question, but
What'd you say your name was?
I'm Eileen Stahl.
Hi, Eileen.
Hi. I wonder if you might speak a little bit about the line between expressing your constitutional right to express your opinion and hate speech, because it seems like this is something of pressing importance.
Mm-hmm.
You know, I think that we kind of, for me, sort of the beginning of that discussion in my lifetime was Skokie, and you know, did the Nazis have a right to march?
Skokie, which is a community outside of Chicago that a lot of Holocaust survivors lived in, and American Nazi Party and the KKK wanted to march through Skokie and have a demonstration that was anti-Semitic in nature, and the ACLU defended the rights of the Nazis and the KKK to make that march on First Amendment grounds, the right to free assembly. Yeah, and that's what triggered your concern. What a great question. So I will give you my handy dandy, which is worth as much as anybody else's. Let's start. Marina, I'm going to give you a gift right now, and you can remember this. My right to swing my arm ends where your nose begins, right? So that's always an image that I held on to because it kind of says the whole thing for me, right? There was a case called Coolidge versus New Hampshire that started what we call the fighting words doctrine. I'm not going to spout a lot of cases. But it was the first time, the question is free speech. It has to be free speech. And as early as 1919, you guys have all heard this, Justice Oliver Wendell Holmes, in one of my favorite opinions ever, said, you have the right to free speech, but that doesn't give you the right to what?
Yell
Fire in a crowded theater. Right? There's got to be time, place, and manner restrictions. And Justice Holmes gave us a measuring stick that was called, it no longer is what the court uses, unfortunately, but it's clear and present danger. If speech represents clear, unambiguous, present, not speculative, it's real, it's now, danger to the public safety or individuals, then speech can be suppressed. This protective box can be invaded by the government, and the government can say, no, you may not conspire with ISIS to chop people's heads off in Brooklyn, because we're allowed to stop your speech even though it's just talk in planning this thing, right? That's a conspiracy or a, you know. The area of hate speech, you can be, as I said earlier, you can be thinking all kinds of hateful things about a person, right? But what the constitutional law has evolved into is allowing legislatures, federal, all 56 jurisdictions, you know, the militaries, Code of Military Justice, or the 50 states or the territories, they may enact what we call statutory aggravators. So what does that mean? That means here in Massachusetts, I could come over, I'm not gonna slap you in the face, right? It's an assault, place you in fear, and battery, and uninvited touching, not in the spirit of pleasantry. A year in jail. Now I can say, I hate women, and slap her. It's hate speech, so the statutory aggravator, if the jury believes, or the judge in a bench trial believes, that I was motivated by my hatred based on gender, or race, or religion, then that 1 year goes up to 2.5 years under our civil rights statute. And the same exact, what we call actus reus, the same act, slapping somebody. If I do it using the N-word and the person's black, that's hate speech, and we decided that even though that person is not going to be hurt any more than the other person that I slapped, that it is so counterproductive to our society to allow people to hurt someone on the basis of race, because of religion, because of gender, that we're going to add a statutory aggravator. We're going to say it's an aggravating circumstance, and we're going to give a greater sanction. Now, where your question is this.
Massachusetts? That
Sorry?
was state?
Yes, it's Massachusetts. We have a civil rights act that says that.
Can you clarify?
And by the way, sexual orientation in Massachusetts is one of the statutory aggravators. It's not in the federal government.
What if you hadn't hit her, but you just said, I hate women, the other? Is there,
If I said what?
can hate speech stand on its own without the hitting?
Oh, yeah, well, if I place her in fear reasonably,
So you don't touch her, but you say, I hate women?
that's just a simple assault. And yes, that could be hate, like, there's a
That
hate speech.
also carries,
Yes,
okay.
but that's an assault, not an assault and battery, and has a lesser sanction than if I batter her.
Got it, thank you.
Right? So, and there's all kinds of, there's even a threat to hurt her, right, is in itself punishable on 2 different levels. One is under the Civil Rights Act, and the other is just on its own as a standalone threat, right? But what Eileen's question really is how, where is this nuanced line between this transgender stuff is costing our schools a fortune. Trying to accommodate all this craziness is costing us a fortune, which is political speech. Expressing an opinion you may or may not believe in. But once I get to the level of threatening, right, hateful speech is one that the consequence of which is to either incite other people to hurt that transgender person, or placing that person in fear, reason. If they're just scaredy cats and they're being unreasonable and being frightened, then I probably win. I hopefully win, even if I'm a creep, right? But if in fact they're reasonably frightened by it, then our hate speech statutes says I've gone over the line, right? By placing a person in fear on the basis of what I do, right? I mean, but then we have all the, it's so nuanced, Eileen, that it's limited only by the perversity of your imagination. You could just keep creating scenarios and say yes, no, and then we could debate them. And we may or may not agree. And that's the beauty of our system too, because ultimately in the case of a criminal, which is what you're talking about, case, we, instead of leaving it to professionals from Washington or from Boston, we use a jury of our peers randomly selected from a cross-section of the community to get together and say, you think that was really hate speech? Do you think that that was motivated? What was the intent of, did Buz hit her because she's a woman? Or did he hit her and she happens to be a woman? And let the jury decide that. And so am I going away for a year or 2.5? Or maybe not at all. She deserved it. Yes.
You must be out of breath, but take a deep breath.
I could talk for hours. He's a professional.
I wanted to follow up with you on what you mentioned earlier in your presentation about gerrymandering.
Mm-hmm.
And were you saying the state Supreme Court said it was okay in those 2 states?
No, actually, 2 states ruled differently and different, one against Republicans and one's against Democrats. And it went up to the Supreme Court, but the people who were bringing it were Carol and Peter Letson kind of people.
Yeah.
And the Supreme Court said, you lack standing to bring that claim. we're sending it back
Yeah.
down to a 3-judge panel to see whether or not it should come here.
So that's
So the
where it
Supreme
is
Court,
now.
just so you know, the Supreme Court, in order for a case to go to the Supreme Court, they have to, people file a petition for certiorari. It's a request that they hear the case. I've written 9 of them. I'm 0 for 9. They've never actually accepted my case for the Supreme Court. But I'm not too offended because there's about 10,000, roughly, petitions for certiorari every year, and they accept between 85 and 110 every year, because every litigant wants to go all the way up to lose, right? So they take them on, if something of constitutional import, which that is, or a case between 2 sovereigns. Oh, Ellis Island. New Jersey said, we own it. New York said, we own it. Supreme Court finally said, how about if the US owns it? And it's a national park, you know? Because, the New Jersey Supreme Court said New Jersey owns it. New York Supreme Court said New York owns it, so finally the Supreme Court resolved. So it's gotta be a case that has universal application or importance. They don't take just anyone. Marina, thank you for coming.
Thank you.
Remember, your right to swing your arm ends where someone else's nose begins. Yeah. No, this gentleman right here had.
Yeah, Michael Nix.
Hi, Mike.
Hi. I was just gonna follow up on Eileen's commentary and then ask you how you thought that related to something like the cake shop decision and the nuance of when a business, when a person engages in hate speech, or a business or a corporation potentially engages in what may or may not be hate speech. And what is the thinking these days on that? I know it's nuanced and it's
You mean by the
argued.
courts, by this court?
Yeah.
Thank you, Chris, for giving your opinion earlier. I really disagree with it. So again, by way of disclosure, I was raised in Atlanta, Georgia. We had a water fountain that said colored and a water fountain that said white, and the same was true with restrooms, and people were beaten up if they used the wrong one. It was like a vile thing if a Negro used a white person's water fountain. And so I saw firsthand.
I grew up in Richmond, Virginia.
My high school was integrated in 11th grade. So you have the monument capital of the world, and you have the slave museum and all that in Richmond. So you do understand, you did have that experience. So for me, I do think to get that kind of institutional discrimination to abate is by governmental regulation. You cannot refuse to serve somebody based on the color of their skin. You cannot, etc. I believe that's where I stand, different than where you stand. I respect your opinion. You're right to have one. Having said that, I think that weaponizing the First Amendment is being done by people who share an ideology that is based on their view of economics and capital, their view that wealth drives the economy, their good faith view of trickle down, their good faith view that the less government is better government. And so that a lot of these weaponizing cases, again, to borrow from Justice Kagan, I'd love to take credit for it, but it's hers.
Right.
I think is a way to foster and promote an ideology that benefits what I would call the ruling elite at the expense of most of us, right? And so most of us includes a great deal of people who are disabled, who are racially in the minority, who are
probably males.
yeah, right. And so I think that the answer is embedded in that starting point, which is it isn't a reverence for the rule of law. I revere the notion of a rule of law rather than the rule of a monarch who says off of their head, I don't like the color of her shirt. Instead, we have a set of laws that we live by, and those laws are calculated to be utilitarian. That's what Jeremy Bentham said, to benefit the most people possible. And to make us love each other as much as we can, and to understand in a compassionate way the misfortunes of some people who were not lucky enough to be born into Chelmsford, and et cetera, et cetera. I think that this is a way to promote that, but I think it's being weaponized to promote an ideological perspective which I don't share, and I think is counterproductive to our health as a society. That's my 2 cents.
Right.
What do you think?
Well, I think a number of things. One, I would agree with you on the control issue that the economic elite have put in place, the ability for them to separate themselves in any number of ways from the rest of us, and economically, physically, legally. But I also think I also think there is a somewhat fundamentalist Christian viewpoint, ideological viewpoint, that's been putting itself in place in government and in educational institutions since the 70s as a long-term plan. That's
Weaponizing.
That's, yes.
The free exercise.
Yeah, so I think it's more complex than
I do too.
than just economics. And so I worry about that, and I worry about how this weaponization is going to play out and or be countered by the rest of us
Right.
somehow.
Me too.
So
I think we share the same view. Yes, ma'am.
Jennifer Brennan.
Hi, Jen.
Hi. There was a couple cake baker issues, and I had read.
The one from Washington State.
Yeah, I'm
Yeah.
not sure which one you were discussing. I thought it
Benton,
might lend a
Colorado.
tiny bit of a clarifying point. Was I had read Kennedy's response, and he described it. It was not overtly discrimination. It would be overtly discriminatory if he said, "You're gay, I'm not going to bake you a cake." And the issue in this particular case that I was reading, he said the issue was the state wanted to compel the religious person to write the congratulations on your marriage on the cake, which was, they said the state is compelling them to speak something. So it wasn't, I don't think, as an overtly discriminatory as
majority
perhaps
opinion.
people think. Right.
Right, and there are two cases,
There's
there's
a
one from
timeline.
Colorado and one from Washington State, and Jennifer is right, that the one from Washington State was ruled on by the Ninth Circuit, forcing the baker to bake, which is one of our circuit courts of appeals, the second highest court to the United States Supreme Court. But the United States Supreme Court, as I said earlier, sent it back for further deliberations because it spanked the Civil Rights Commission of Colorado because it had been forcing, because of the language, because it said inherently biased language, prejudiced language, was used by the Civil Rights Commission. So you're right, but there's no question in my mind of what underscored that opinion. And I didn't like Kennedy's language at all, especially since Kennedy is like historically Mr. States' Rights. Like, he's the one who thinks that entity, the sovereign, should be the state. That's his lifelong pursuit. Anthony Kennedy, the retiring justice of the Supreme Court. So I found it very interesting that he was saying that the Civil Rights Commission of Colorado, whose job it is to make sure that nobody's civil rights are being left unprotected, was being overly zealous in saying to the baker that you have to, as long as it's not something that is vile, like something obscene, or that they were asking be on their wedding cake. Yeah, right, that they were able to come in and order. The Colorado disagrees with Chris, right, that you should be able to tell a baker that if you want to open to the public, you have to open to the public. You can't discriminate on the basis of your personal prejudices.
Oh, I agree with
Go ahead.
I was going to say, and I turn this around to my friends, because I have friends on both sides, and I say, well, if you were a baker and someone came in and said, you know what, I'm having a party, I'm so excited Trump won, I want you to bake me a cake and say Trump's the best president ever. You know what I mean? So are you going to turn around and say, okay, the state can force you
That
to...
isn't the same question.
compel speech. It's a
No,
compel
that's not the
speech
same
issue.
question. No, because you're motivated there by a political ideology that's different than racism or, in this case,
Okay.
I'm going to say homophobia, but that in itself suggests my viewpoint, but
Okay.
an anti-homosexual prejudice, which is articulated by the baker, right? Masterpiece Baker, he says. I
Okay,
don't
so you're
like-
separating religious from political beliefs.
Because of my
Okay,
religion.
Okay, okay.
I think that's evil, I think it's sinful. That's different than saying, I'm a baker and I don't want to put Go Trump on the cake, I'm not going to do it for you, because your reasons there aren't, don't involve a protected class. It doesn't involve discriminatory motivation towards an otherwise protected class. In the federal scheme, homosexuality isn't a protected class for these purposes. In the state scheme, it is. In Massachusetts, it is. If I beat up Peter because he's homosexual, as I said, that's a statutory aggravator, right? Because we have a civil rights statute that says sexual orientation is among those protected classes. Race, creed, religion, sexual orientation. In Colorado it is too. So, but your point is a good point, and there is discussion there. I just have to ask a question. I have to think out loud. I was only allowed 2 hours, and I got here at 9:21. So 11:21, my meter goes, that's all right, I'll pay. How much is it? Was it $10?
If you are at a library event, you can go upstairs and they will write you an excuse.
All right, let's keep going, Karen. I know who I am, I was at a library event.
I heard you correct yourself several times today. So if it's a shortish, okay answer, what in the law system, in the courts, what's the difference between bias and prejudice? Because I've heard you correct yourself several times.
Yeah, I misspoke several times. Not a new event. Yeah, I think that society uses bias in a broad way. Here is, the difference is an irrational preference based on a rational concern. So here,
Which is that?
my granddaughter is the prettiest child in the history of humankind, but I'm a little biased. That guy is Catholic. I can't stand Catholics. I'm a little prejudiced, right?
Oh.
So prejudice is an irrational propensity against something, while bias is an irrational propensity towards something, and I don't know why, but people always use bias to encompass both. But
Okay.
bias really is, I love you, I love every one of you because you came here to listen to me this morning, but I'm a little biased. Right? And I hate those people who didn't come, I'm prejudiced.
Okay, thank you.
I want to hear who didn't have a chance and who had their hand up. Yes, Peter?
I have my hand up.
Go ahead.
We're Quakers and tax resistors. And it seems.
Well, we hate you, we're prejudiced on 2 counts.
And it seems that the insistence that we pay an outrageous amount of our money to support war, which is against our religious training and belief, we should be somehow protected from having to do that. That's the scoop.
Want me to answer? Does anybody want to take a stab? Okay, so here's the issue. It says in Article 1, Section 8 of the Constitution that one of the powers of the legislative branch that we glossed over before is to tax, right? Despite what Rand Paul's father says, they have the right to lodge taxes. And so the social, I wanted to say needs, I'm catching myself, because that in itself is loaded, but the decision by those, we're a representative democracy, we elect representatives, they decided that we need to tax, and we're gonna do it equally across the board in accordance with some formula, right? And that's what it is. Now, you say that conflicts with this, which is our religion says if our funds are being used in a way that is an affront to our religious belief, what we believe God wants us to be doing, then in fact it's an undue infringement on our religion. So we have to take this fundamental right and decide whether or not that's one of the exceptions, because we're going to make a lot of exceptions in religion, right? where religion cases, if you ever get a chance to just look through almost any sort of, doesn't have to be scholarly, but they're delicious cases. I'm just trying to think of one. Starting in, here's a very famous one. It begins with a Y, and I can't remember the name of the case that went up to the U.S. Supreme Court. And here's what people said: we are this German in Pennsylvania, the
Mennonites? Amish?
Amish. Thank you very much. They weren't Mennonites; they were Amish. And there's a compulsory attendance in public school up until you're 16 thing. And they decided that they didn't want their children, to be exposed beyond 7th grade because of all the sexual stuff and the competition and all that. So they felt that it was unconstitutional. And by the way, this is why we have homeschooling now, because of this case. Because of the why, and I can't remember the name of it. But so what the court finally did is it had to navigate between their religious view that their kids shouldn't be involved in dating and whatever else was involved there in middle school. I don't want to tell you what was involved in mine. I always think when I'm worried about my memory fading, I always think if I could just delete 7th and 8th grade. But versus, their religious freedom versus what most of us believe coming out of the early 20th century was a good idea to have child labor laws that says you can't make kids work under a certain age, and compulsory public education so that everybody starts off with basically a good education. Those were complicated at the time. Farmers said, wait a minute, I need my kids to work on the farm, and finally they said, okay, you have to go to school until you're 16, and now these people wanted to make an exception. Well, the court did, trying to navigate these choppy waters between their religious freedom. But they made such a good argument that kids will learn about community because they work in the community, in the Amish community. They'll learn about, and we'll teach them these other things that they need to know in order to be productive members of our society, right? Mm-hmm. So you're just raising another instance where your religious beliefs conflict with what society has decided to our elected representatives is a good idea to just raise money through uniform taxation. But you're saying, in particular, I don't want to pay war taxes. I'm willing to pay money, just not ones that go to fund bombs and tanks, right? And so far you lose, even though I represented Randy, as you probably know, Randy Keeler, so I'm very familiar with your feelings and respect your opinion. But the courts have not yet said that you don't have to pay. What the government has said is, okay, we're not going to enforce it because it's such a mess when we do, so they don't enforce it very often. That's the best I can do.
They don't enforce what?
He's a war tax resistor and he's not in jail. They're not in jail.
Because they keep getting the money from other accounts. Yeah.
Oh, is that what they do? But they haven't jailed you.
No.
But you have to pay the full amount of the tax.
Well, some people actually pay to other charities and things like that, and they send notes, and they don't often enforce. Although Randy Keeler, our neighbor in Coleraine, he did a couple of years for this. Years ago, I represented him on part of that case. Yes, ma'am, I'm a camera person.
Speaking of people you've represented, I know that you have and maybe still are representing prisoners at Guantanamo.
I did direct representation now, but I'm one of the, I did it for 12 years, so I'm like one of the old veterans that advises the young sprouts that are doing it.
Are there any of your cases or any that you know of that come to mind that have, that illustrate defense of the First Amendment?
All 8 of my cases, I invoked the Religious Freedom Restoration Act. If you know what that is, that was after Smith versus Oregon. No. Yes, I invoked their religiosity as a ground on every one of them. And as I said earlier, in 2 of them, the Supreme Court declined to hear my case. And other cases in which I was a party, companion cases, we call them. Smith, speaking of Peter's concern about war tax resisting, interfering with his religious freedom, and why doesn't the law accommodate it? Smith versus Oregon in the 90s there's no better example in my view of such a case. What it was is in Oregon, 2 Native American young men were, by all accounts, great drug counselors in a state-funded drug and alcohol substance abuse program. But every Saturday, they did what by treaty was guaranteed that they're able to do. They went and took part in the liturgy of their Native American tribe that they and their ancestors had belonged to. And part of that liturgy, just like taking communion, they did peyote on a Saturday. So here they were, drug counselors who on Saturdays, every Saturday, did some peyote to get in touch with the Great Spirit. And until their supervisor found out, and they were fired, both of them. One of them's name is Smith, and the other one, I can't remember because I still have 7th and 8th grade. So what happened is they had worked there for a long time, they applied for unemployment insurance, which is guaranteed because they were fired for not just cause. They claimed that they were fired because they were exercising their religious freedom, and this is part of their religion requirement, is that you do a little peyote to get in touch with the Great Spirit, do a vision, what do you call it, vision quest, and all that sort of stuff. And so what happened is it went up to the United States Supreme Court, and in a very famous opinion, Justice Scalia, who else, he wrote that the real test here is whether Oregon's right to pass drug laws forbidding the ingestion of peyote was one of those time, place, manner kind of exceptions to their right to religious freedoms, such that they should not be able to collect unemployment insurance because they weren't wrongfully fired. It was a just firing because, putting aside the fact that they were drug and alcohol counselors, teaching people how to get off addictions, right? Although he didn't really put it aside, that was really part of it, he wove it into his opinion. But Smith versus Oregon made a lot of people angry in Congress. This is like 90, I forget, 6. So the Supreme Court ruled 5-4 against these 2 men. They didn't get their unemployment insurance, and the right of the state to say, no, you may not get unemployment insurance, surmounted their religious rights. Congress then passed the Religious Freedom Restoration Act, which tried to rip that question away from the Supreme Court and put it in the hands of our elected representatives. And eventually, that portion of the Religious Freedom Restoration Act was found unconstitutional because only the court has the right to interpret the Constitution in weighing this. And that Congress was trying to strip it. Did you just Google it?
No, I didn't. No, I'm gonna go read about it because it's something that I haven't educated myself about. So.
It's a really interesting case, and read about the Religious Freedom Restoration Act.
Yeah.
Good. So Beth, the answer to your question is for every one of our Guantanamo detainees, my clients, I argued to that portion of the Religious Freedom Restoration Act that they were being held based on their religious beliefs, not because there was any evidence that they had ever taken up arms or otherwise been on the battlefield against the United States. And that was right, that was true. They've all been transferred back to their homes, except for one who's in Uruguay. That's it, that was my 12 years there. And now I'm just sort of an old fogey that they say, do you have this motion in Word? And so I send them the motion in Word and I'm a hero, because I'm helping them do the work, that's it.
Why do they have a First Amendment right? I'm doing devil's advocate question. Why do they have a First Amendment right being prisoners of the...
Because in a case called Rasul versus the United States, that 45 square mile naval station that we have in Guantanamo Bay was deemed to be the sovereign of that is the United States, even though it's in Cuban soil. Because we have it by leasehold, we stole it fair and square during the Spanish-American War for $4,000 a year that Castro never took. But nevertheless, we have a right in perpetuity to that 45 square mile space. Even though the soil is Cuban, the sovereign is the United States. So anyone who is brought there, we argued successfully, has the right to all the rights of somebody on U.S. soil, including habeas corpus rights, which is why we brought habeas petitions on their behalf, and why we could invoke the Religious Freedom Restoration Act and a lot of other stuff that we did in our litigations over those 12 years. Yikes, Alice.
Well, yes, everyone has asked all questions I probably would have asked, and so, but I have a question about.
Not all the questions you would have had.
Not all the questions, no, there would have been many, but I'm an artist making art, and a small collection is part of a larger collection, and the small collection is called Egalitarian. And so I'm wondering, aside from I don't want you to pick out words from the First Amendment, but when I consider the political, social, and economic equality of people, what is the fundamental everything that I could stress in my artist talk from the concepts here? What is the underlying intention that can transfer to teaching young people, especially high school students, about being egalitarian?
Well, you're asking me not to use words from, and that's what we do. We use words. But look, you could go back to the Declaration. It was a big deal. Declaration, if you read it out from March to July 4th, it was a big deal. And it was difficult to negotiate what that language should be, but even though now those of us who want to see the Establishment Clause respected don't like this, but nevertheless, the language says we're each endowed by our Creator with certain inalienable rights, right? Certain inalienable rights. You can't take them can't alienate us from those rights. So each of us are born with ears and eyes and legs and these rights is basically what they're trying to say. And then, as I said before, in 1868, 3 years after the Civil War ended, we did the 14th Amendment. Congress amended this beautiful document, the Constitution, by adding a 14th Amendment that added the Equal Protection Clause, right? It said, no state shall deprive people of any person of equal protection under the law. Equal means equal, right? So it took a long time to figure out that that means that women are citizens and should be able to vote. You know, I was born in 1950. In 1950, women couldn't sit in a jury in Massachusetts. In my lifetime, women couldn't sit they weren't deemed capable of making a decision about whether or not the government had proven beyond reasonable doubt to a moral certainty the guilt or innocence of somebody. That women were incapable of doing that or incapable of voting until we amended the Constitution for that. I mean, that's what our history is recognizing our differences in a pluralist society and not just tolerating. And tolerance is I always thought a funny word. You know, it's not like we're tolerating your differences. We're celebrating your differences. It makes us stronger that we're different. And so I think, Alice, that the language of equality is not to be. If I were talking to young people, I would say what I just said. I would talk about how that was a core principle in the Declaration that said, King, we're not with you anymore. We need to be independent. And part of that is because we're endowed, we're born with certain rights that you don't respect. And those rights are as core to our existence as our lungs are. And we then fought a civil war because some people felt that owning people was is our choice to run our economy the way we want. Free labor is what we rely on, and you don't tell us, mister. So we're going to set a new course, and Lincoln and the North said, no, you're not. You know, we're not going to let you do that and then created an Equal Protection Clause that we're governed by. And then, now the question is, okay, what is that? So then ageism was addressed, or mental retardation was addressed, or things that make us different, things that make us unique, each one of them is examined to see whether or not that should be under the purview of the Equal Protection Clause as well. I mean, I don't have an easy answer, and I probably don't have an original one. Probably nothing you haven't thought of before, but those to me are sort of hallowed words.
Yes, it's very good language. Thank you so much.
I didn't think that. Yes, ma'am, yes, ma'am.
Okay,
yes, ma'am, first, then yes, ma'am. I
So-
promise not to slap you this time.
So I'm trying to really
Sorry.
think about pushing at the edges of this. So corporations are people, and money is speech.
Corporations have the same rights as people because they are a consolidation of people, yeah.
And the right of people to peaceably assemble, that's the piece that lets people go to lunch counters and stuff like that, right? Have I sort of got that?
Well, it's what allows us to go to a meeting at 10 o'clock and hear from radical attorney Buz Eisenberg. And it allows
here's my
us to
question.
march on the speech street. And it allows the three of us to sit and talk about how we hate Donald Trump in the town common. It's to freely assemble.
So I want to go someplace owned by a corporation that's not accessible. And that's my right to peaceably assemble in a place that's open to the public, right? The corporation says, we have a religious belief that people with disabilities, their disability is a judgment from God. You can't compel us to spend our money making our business accessible because it violates our right to free speech and religion. Is that kind of?
Chris, where do you land on that one? Should they have to accommodate for disability or because they're a private enterprise?
I think the easy answer is, and the easiest way to be consistent is to say no. Now, when we get back to the shoveling a sidewalk and lots of businesses here, I think the sidewalks are on an easement. You really don't own the land. You have an easement to that, and I don't know this area of the law very much at all. But I think if it's on an easement, shovel it. If it's your own sidewalk, don't shovel it.
I'm a sole proprietorship. I'm petitioning for the licenses, the Board of Licensing Commissioners of Greenfield to open an ice cream shop. They say to me, well, you have to satisfy the building code requirements that you put in a ramp. You're a sole proprietorship, you're not a corporation,
Right.
Buzz, but you have to put in a ramp to accommodate people who are in a wheelchair, right? And so the question, and your question is, should I, what?
Is
Can I
my
say-
right to peaceably, how does the corporation's personhood and their money being speech
You guys are
balance
great.
against
You guys are
my
great.
right to peacefully assemble?
Listen, this gets so exciting. See, now I'm gonna get excited. I'm gonna get excited. Listen to this. Hang in there. Because along with what Chris is saying, what he's saying is, I disagree with him, but it's not outrageous and it's not like there's no logic behind it. There was a case called Bloomfield, I think it was, in New Jersey in the 40s. This crazy concept called zoning. You may not sell your land to Peter to build a house because it's gonna be like cookie cutter, and we don't want our community to have houses like in the Levittown development kind of thing, and that means we're gonna have more school buses onto the road that's gonna be created there, and we're gonna have to, and our fire trucks have to have a turning radius, so we're gonna do what's called zoning, right? We're gonna tell you what size a lot can be. Wait a minute. This land has been in my family for 7 generations. You're gonna tell me what I can do with my land? It was a big deal, right? So it's government the right to regulate in order to promote a social perception of what's necessary. Well, when it comes to commercial entities, now all of a sudden we have everything like accommodating disabled people, public health requirements that whether you have clean premises or OSHA requirements, whether there's safety in the way that workers are in the conditions of the workplace, and all this government regulation against, in this case, a sole proprietor. Who the hell are you to tell me whether, I have to sweep my floor twice a day or 3 times a day, right? So we're constantly navigating this inherent tension between the rights of the individual and the right collectively to regulate the activities that happen as part of our society. And the more complex society gets, the more we move away from this individual choice, and we're having these people in Boston that we hate regulating, you know, what color our houses can be in Cape Cod, right? Like, what? How can you tell me what color my house can be? I want a pink polka dot house and I own it, right? So, I don't know if I addressed your question. Not really, so ask it again.
There is no one answer, I think is what you're saying.
I was getting excited, I'm sorry.
So my question is, on one side of the equation, you have a corporation and their money, which is speech, arguing that they've got a religious belief that in some way justifies feeling that they don't need to spend money to make their place of business accessible to people with disabilities. So my right to assemble versus their right to free speech and religion.
Right. So.
But assembly only, that's on public, that's on the town square, that's not in a private business, I think. I mean, so
perhaps it is.
Okay.
You know, I mean, there's a whole trespassing component, it's a complicated question. But I understand the tension that you're trying to draw between the right of the owners, the corporate entity, and your right as an individual to have access, right? So I mentioned before here's what we have. I'm getting a little bit scholarly, forgive me, because I've studied this stuff my whole adult life and I love this stuff. I'm not going to go into Latin much. But there's two concepts, malum in se, plural is mala in se, and malum prohibitum, malum prohibita, plural, right? And here's what it says. There are certain, you can never say always, ever, right? You can never, but it's almost timeless, universal, throughout societies, whether you can go back 8,000 years to, you know, Hammurabi's code. Raping an infant is a malum in se. It's intrinsically wrong in almost every society, right? It's true that the Mayans would take virgins and throw them into the gods, you know, whatever, at 13 or whatever, but it's pretty timeless and universal that you don't rape a child in most societies. That's a malum in se. And then there are malum prohibita, which the people that decided that Peter's got to pay a tax decided that on April 15th, everybody paid it. It could have been January 1st, it could have been whatever, and the method of doing it in the form that we use, it's just a malum prohibitum to not do it. It's not that it's intrinsically wrong, it's that we decided through our elected representatives to do it. Our mores suggested that they do that. We're on the Mohawk Trail. Route 2 was a migration from Ohio all the way to the Cape of the 7 Mohawk nations that traveled. And when you had an old person, they would put them on the litter, and when they got so feeble that they couldn't make the trek to follow the salmon to the Connecticut or to follow, you know, to the weather to go to the Cape, then the individual elder, disabled person, leave me here to have their eyes pecked out by eagles or whatever was going to happen, right? But they felt that was the right thing for the whole to do. We decided that we should accommodate the disabled. We should put elevators in our elementary schools so that they could get to the second floor. That we should make sure that no person is being treated in a disparate way just because they are in a wheelchair or otherwise disabled, learning disabled, or whatever. We're going to accommodate that. That's a malum prohibitum. We decided, it's not a malum in se, it's what we decided to do. It's different than what the Mohawks decided to do. So we have handicap spaces and do all this sort of stuff. Our Article 1 legislature, we have norms. Some norms we call folkways. We wear our watches on our left hand. I don't know why. We wear wedding bands to display the fact that we're married on a certain finger on a certain hand. These are called folkways. It's not like you're ostracized from society if you don't do it. I'm married 47 years and I don't wear one. So I can hit on babes like you, Jen.
I knew that was it.
But then there are other kinds of norms that we call mores. And mores are values. And our legislators elevate some of those mores. You know, some of them are in between, like don't butt in line for lunch, right? But some of them are really don't hit somebody, right? Those mores are often codified into a criminal code. Thou shalt not have an intimate relationship with somebody under the age of 16 if you're over the age of 16. Thou shalt not, right? Those mores get codified into, you'll go to jail. You'll lose your freedom, that which we all, our most precious, you know, call it commodity, whatever it is freedom. But you'll lose your freedom if you violate one of these formerly mores, now criminal defined as a crime. Our legislators decide what to do about people who have disabilities, and they've decided largely in most states that you have to, private business, I don't care if you're a sole proprietor or a corporation, you have to make sure that if someone who's able-bodied can get in, that somebody who's not able-bodied can get in, and we're going to require that in the state building code. Or else you don't get your permit, you don't get your license to open your business, right? It's more complex than any of us want, because why should I have to get a permit to sell hot dogs on the corner? Well, you do. You have to. We decided that's what we're going to do. That's to make sure nobody gets poisoned. We have Board of Health, we need your hot dogs, right? That's just, I think the answer is, that's why we have a legislature that makes laws, right? And we also delegate to those agencies that are created by the legislature. I forget what it is, but a department, who does the state building code? Whatever that entity is, it's a regulatory agency. You can pass regulations in the executive branch to say that you have to have a certain turnaround zone within a bathroom so that somebody can utilize your bathroom in a wheelchair, unless you're grandfathered or less and less and less, right? So I don't know how to really answer your question other than those choices are made every day. And by weaponizing the First Amendment, it's giving the right to say, government, you shouldn't be passing those. It is more of what Chris likes, which is the right of the individual to be a jerk. He'll boycott the jerk because they don't accommodate your wheelchair. But he thinks government shouldn't be involved, or at least he says.
Well, I think there's a difference, in my opinion, like, you know, communicable diseases, fire codes that might jeopardize the building next door reasonably is different than
I don't like you
the ramp.
Oh, or then the ramp.
Right, because that's not jeopardizing the business next door or the health of the community.
Yeah.
It's just being a jerk, or it's just and you know, I even take it away from I don't think you have to have a business reason. I think by denying these 3 customers, you know, it's just a business decision. The cost of the ramp far exceeds the return I'm going to get on that investment. I mean, again, it's a jerk, and I wouldn't knowingly go into a business that does this. And I just think there are all sorts of practical problems too, like the baker. You know, so you go back to baker, you got to make the cake, and the baker, oops, did I make a mistake? Did I get a scoop of salt for the frosting when I meant to get the scoop of sugar? Oh, darn it! You know, I made that mistake before once. You know, I just think it's not worth. Now we're going to take that case back to the Supreme Court because the frosting was too salty for this cup. I don't know. To me, it's just it's not worth it. But again, I think they're jerks, and I wouldn't knowingly, and I don't think the government, I think the public library has to have a ramp. I think, you know, anybody selling hot dogs on a public sidewalk, I think you got to shovel the, you know, on the easement, because that's public property that you are giving to care of. But I don't think the dress shop that I live over, I can't go downstairs and say, well, you know, sell me a pair of pants. You're discriminating me based on my gender.
Well, the
I think
law
things
doesn't
like that
have
are
it.
ridiculous.
Yeah, that doesn't.
Well, I understand. It's a little bit ridiculous.
Yeah, no, the law wouldn't require that.
But again, I can buy a birthday cake from that baker. He just says, I don't want to make a wedding cake for you.
No, and the law also, the bona fides, whether it's employment, if I apply for a job as a Playboy bunny, they're allowed to say you don't have the equipment necessary for this job. It's a bona fide employment criteria. You had your hand up again.
Yeah.
Elaine, I'm going to hold off on you because she's been, go ahead.
I think I'm up to 6 or 8 questions by now. Let's see which one
Oh,
I want.
no.
Which one I want to do.
You were
So,
really gonna get
as a municipal official, I found that I often reverted in my thinking and occasionally in my speech talking about the public good. And I think that that's a concept I actually believe in. The problem with that, of course, is it always depends on some human's interpretation of what is the best good for the most.
I know what you were thinking when Chris was talking.
Yeah, and several other times that's
Right.
come up in my thoughts. But I think I'm not going to question other than to say, other than what we've already talked about, is the phrase "the common good" does that exist legally?
Yes.
It does.
In many incarnations, but yes.
Okay, and
The
then-
concept is core to this tension between the right of the individual, the rights of the individual, and the right to regulate. It's core, the notion of a public good, that the reason why we say the town of Greenfield can require that you clean up after your dog, you know, your right to just let your dog poop is surmounted by everyone else's right not to have to poop on their shoes, right? And the public good requires it. So yeah, it's core. That concept is rippling through every
But you don't
one
have
of
to
these
pick up
cases.
the poop in your own yard if you don't want to.
You don't have to pick up the poop in your own yard. The public good that is not impacted in your own yard. Trespassers can step on it.
Until it smells.
Oh, until it smells.
That's
Okay.
that's the end of your nose.
I would agree with that.
All right.
So I'll revert to my original question, which is way back at the very first thing you said. You define enforcement as a function of the executive branch, and yet I find I usually think of it as a portion of the judiciary branch. And I can see how it falls into either side in different cases, but
No, the judiciary branch doesn't carry guns.
yeah.
It has a gavel, but if nobody listens, then it doesn't matter. They just wear robes and
And they
just
say you're
have
gonna go.
mouths.
And they say you're going to go to jail.
It's up. Well, yeah, but
That's
then
not
we need somebody in the
enforcement.
executive branch to actually put
So
you in
police
jail.
are executive.
Police are executives. The jails are owned by the executive branch. That's right. So, yeah, we're the ones without the force. It's only the goodwill of the people that allows the judicial branch to say you're going to jail and to actually do it. We rely on the to execute the law or the order of the court. So it's to enforce and to implement. So implement is April 15th, you have to pay your taxes. Congress says that. Now the IRS, the Internal Revenue Service, a branch of the Treasury Department, has to actually execute, implement the requirement that we get everybody to pay their taxes on time. Enforce is you're not allowed to slap somebody in the face. Somebody does, and the executive branch has to enforce that law. The judicial branch will determine whether you're guilty of it or not. And then we have to get somebody to jail you from the executive branch. So, yeah, I don't know if that
Thank you.
answers.
Yes, it does. And while I've got the floor, I'm going to cheat and keep going. So as opposed to the common good, can you talk about the public trust?
And you gotta give me a context because I can think of 3 different ways to talk about the public trust.
Well, let's talk about our children's trust then. That's, we want to go that direction.
I'm not sure where you're going, so why don't you can. You talk about the public trust.
Julia, is it?
Juliana.
Julia is suing.
What brings you to our planet? And he says, your planet. And that's what these kids are saying. It's not the United States planet to destroy for our future. Well, this notion of standing, whether something is judiciable or not. My daughter is 48 years old. If I were to, when she was a child, as her next friend, I could bring an action on her behalf as her, we call next friend, as her guardian, as her adult parent, right? Now that she's 45, if I bring an action on her behalf, they'll say, no, you don't have standing to bring an action on her behalf. She has to bring it on her own behalf because she's an adult, right? They're claiming that the kids don't have standing, in that case, to speak on behalf, as we talked about before in the other case. Anyway, that it's non-judiciable, and that's where the public trust, who has the right to speak to humankind's future? Do any group of 20 kids have the right to say our planet is being destroyed by the Trump administration, we want to sue? The trial judge said, I agree with the kids, they do have standing. The Ninth Circuit Court of Appeals said, I agree with them in part. And it's pending, part of it is pending right now. And U.S. Supreme Court, Justice Department is saying, they lack standing, throw this case out, they don't have the right to claim that they speak on behalf of the planet.
The Supreme Court has said that?
No, the Justice Department is asking the
Yes,
Supreme
it's
Court to say that, and fortunately,
He's giving several levels
from
of-
my perspective, fortunately, the Supreme Court went out of session for the summer. So right now, it's in 3 different levels, at the trial level and the Circuit Court of Appeals level and at the U.S. Supreme Court level, all involving who can speak on behalf of the public trust. What do you think? Could you? Could you sue and claim that environmental policies of this administration are damaging your right, fill in the blank, to X, Y, Z?
Probably.
You feel that you should.
If I'm asthmatic and it's, they've got a policy that's affecting the air, sure. I mean, if that's the issue that's before, who they said didn't,
I don't think you have to be asthmatic to make this argument.
well, that's true. Do
this
you
point.
breathe?
Yeah, exactly.
Okay, yeah.
You breathe, you have
I mean,
lungs.
I spend a lot of time working on what are considered externalities, whether corporations have the right to produce a product and not account for the full cost accounting of their product within the cost of that product. So I work on
Social cost of that.
I work on product stewardship laws, trying to bring more of those.
So you work on
things
public
in.
good and public trust all the time.
Yeah.
It's your job.
Well, it's not like I always get paid, but yes.
Yeah, ostensibly that's what you do.
Yeah.
The social cost of these
Right.
corporate decisions.
Right.
And whether we should all bear the cost.
Well, partly that comes down to the difference between the taxpayer and the consumer, because the corporation will ultimately pass the cost on to the consumer, but which is appropriate, but the consumer and the taxpayer are not exactly coincident. If I decided not to buy that single-use plastic water bottle, why should I be the one paying for the recycling of it, never mind the disposal of it?
I love that question. The answer is, to me, you shouldn't.
Can we go back over to that question
Which question?
about the plastic water bottle? Sorry, I was distracted for a second.
She was explaining that her job, which is to calculate the real cost of corporate decisions and business decisions, and she has to, and for example, she looks at the cost to the consumer and the cost to the taxpayer. Sometimes they're coincident, sometimes they're not, but why should we all have to bear the cost that corporations make of that plastic water bottle? It's part of what she tries for a living to figure out, all of which stems from her question about where the notion of public trust and public good, two different things, fall in the law. So I just recapped, and all I said was blah, blah, blah.
Because I think that's interesting, the true cost, oil reserves are, a several million-year-old bank account that we're just, we're withdrawing from, and the true cost of doing that is, we're not really paying.
Who's we?
Well, the people, anybody that uses petroleum, the true cost of a gallon of gas is more than $3, in my contention. Because, we're not replacing, we're not doing it in a sustainable way.
I'll point back to a great essay called The Tragedy of the Commons.
Wow, you guys should all be up here speaking. Elaine had her hand up before.
I'm Eileen.
Eileen had her hand up before too.
Close enough. Gosh, this is also interesting.
It is. People are interesting here.
Also interesting. So, you were talking about two different concepts with legal terms I hadn't heard before,
I'm
but
sorry.
one was essentially like something that we all agree is the legal equivalent of a mortal sin.
A malum in se.
As opposed to some.
It's bad within itself, malum in se.
Malum se, as opposed to something that we agree is bad for the society.
A malum prohibitum.
Okay, so I want to talk about the Malum Prohibitum, or I want to ask about that in the context, because I'm really stuck on this, of a sole proprietorship saying, putting a sign in the window saying, no Jews allowed. Suppose that by one sole proprietor in a town doing that, proprietors feel supported and emboldened to put signs in their windows. Now I'm driving late at night through some little town and, you know, there's no stopping place in sight and I'm sleepy and I need to get off the road and gosh, I need a motel room for the night. And the first place has got a sign, so I can't stop there, and I go across the street, and that place has a sign, and that place has a sign. I guess the question that I'm trying to ask here is, if individuals are allowed to do this, it kind of aids and abets a social ill by validating it. Isn't that I want to call it a Malum Prohibitum, but that's not what it is. Isn't that societal evil, legal concept?
I think, Eileen, what you just described is the march of history. That's what has happened. That as society progresses, as within our embrace we bring people in, immigrants that might not, they're Irish and they speak funny, they're Italian and they speak funny and they have different customs, and then they're Asian on the West Coast, and some of them, instead of eating with forks and knives, they eat with chopsticks, and they listen to different music, and then the inner city, Hispanic communities grow up that eat tacos and that dress differently, and that now tattoos and whatever. As society changes, the people we elect bring their mores from their districts, their constituents, to Congress. That's the theory. And eventually they'll say, you know what, it's counterproductive for us. Disabled people add, not detract from our society. Some of our greatest scientists were disabled, or were Jewish, or fill in the blank, right? That's the way it's supposed to work. The problem with having a bunch of fat, white guys who look like me running the country is that you might not get that sort of perspective that you want of having people of color and people of different backgrounds that can articulate a different set of mores and a different set of values, so that collectively we can say, okay, what really enhances the growth of us as a people, as a nation, instead of just sort of perpetuating the same view of right and wrong, or of values and mores. And, and I think when I was a teacher, I'm sorry, Chris. I'm just going to tell you the best answer I ever got on a quiz. I was talking about exactly this. There's two types of norms. They're both ways, and there's mores. And I asked on the first quiz of the semester, what's a more? And this kid wrote, when the moon hits the eye. Full credit. He got full credit. But I think you're just articulating, Eileen, exactly why it's better to have diverse lawmaking. It's the legislatures on the state level and the federal level that make the law. And if they bring to that lawmaking function a set of mores that are more expansive and reflect a lot of different types of communities, cultures, I think we grow as a people. We're a pluralist society. I don't know how to answer your question other than by saluting.
I want to know how this gentleman answers my question. I'm sorry, I don't know.
Chris.
I want to know how you answer my question.
Well, I think it's an unfortunate situation, right? And again, I wouldn't do that.
Unfortunate situation, okay, but like,
Well, hang on.
if I end up.
Okay, but
if you ask him for his, you should listen.
Historically, and maybe you can help out because I may have some of the details wrong, during the early part of the 20th century, when there were still all kinds of problems in the South with blacks, and if you're Jewish, you might be able to just, well, I guess usually in a hotel they want your driver's license and they want your name, but you might try to pass. But to me, I think that's just a business opportunity for someone to go in and say, there's a segment that's not being served, I'm going to go in and serve them. And during I may have the history wrong, but there was something, I think it was called the Green Book, that African Americans who traveled across the South, there was a business opportunity, and there was something that they had if they were driving from Alabama to Virginia to see family or whatever, that they had, and this is even before you had a smartphone ability to do this, and it said, in this town, go to this place, in this town, you know, make sure you get gas here so you can make it to this other town, and it happened. And I don't, like I said, I don't think that's ideal, it's not something, but a business opportunity was created, and therefore the businesses that were open to these people benefited greatly, and there was a publication. Do I have it right? Do you know anything about this?
Yes,
what's the
but
Green
I
Book?
just so disagree. I mean, my experience is very different than yours, and I don't, it's just.
Well, this is before my life, but it's just something that
I
I know that
during
happened.
my life.
And I think it's unfortunate,
It
but I
wasn't
think from a
before your
rights
life.
standpoint.
It was through the 1980s.
During my life, I was suspended 13 times from high school and what was then called junior high school. 8 of those were for getting in a fight. We used to meet out back when I was called a dirty Jew. And so rather than cower away from that, I would go outside, get in a fist fight, and then be suspended. That happened to me 8 of the 13 times. I won't talk about the other one. But when like I said, when I was in 11th grade, we integrated and brought in, we had 4 Jews in my high school, Lakeside High, in Decatur, Georgia, and brought in 4 black kids. And I can just tell you dreadful story after dreadful story. I can't even understand what business opportunity means in this context, because I saw horrific things happen to real people because of the color of the skin or the temple that they joined, or things like that. So my experience is just really, we're all products of our experience. My experience is really different than yours, and I wouldn't couch it in terms of business opportunities. What it was society hadn't grown to the point where it accepted people because they were different. And the more homogenous people were, the more they looked like what was thought to be the way that people should look and the way that people should act, was acceptance. And anything outside of that box was unacceptable, intolerable, to the point where, you know, every Memorial Day, when we're celebrating people who've given their lives for this country, I have my own thing. Speaking of militarism, I think, you know, we do that at Memorial Day, and then what was Armistice Day to celebrate peace in November is now Veterans Day, and we celebrate exactly the same thing. I make sure that I celebrate those people who gave their life, those 4 workers in Mississippi, Philadelphia, Mississippi, who gave their life for freedom, to fight for civil rights, and all the people who weren't wearing uniforms, who have given their lives and suffered in order to make it possible for people of all colors and stages of ability and religions to be able to flourish and to have a life worth celebrating. My experience is really different than yours. I've seen too much suffering.
Well,
and I've
have any of
represented
these
people on
laws?
death row who are only there because they're black. And right now I'm representing immigrants.
But we have all these laws, and there's still people on death row only because they're black. I don't think the laws change people's attitudes. I really don't. I think in many cases they allow hate groups to flourish because people point and look at the government telling me what to think.
You can say that, but I don't want to argue with you, because I don't argue with you. But women would not be voting now if laws didn't change people's attitudes. They really didn't have the right to vote. We had to make a constitutional amendment to allow women.
What changed first, the law or the attitude?
The law changed the attitude.
I disagree.
Well, you know what? The Civil Rights Act, you don't have to disagree, because every single poll was opposed to the Civil Rights Act.
How do we have
Right, we're gonna get far.
gay rights now? What happened? People saw the writing on the wall, that the majority of people supported it.
Just so you know, the Green Book was a Green Book. It was printed for the first time in 1936, and it still was used as late as the 1990s.
Okay, I didn't know it
That's
went
not a
into the
business
90s.
opportunity, that's sheer discrimination.
Well, it's both. It's both.
All right, you guys should carry this on afterwards.
Yeah.
I don't know. All right, we have one more question.
Business opportunity?
I'm sorry, what?
You guys should continue this afterwards.
Yeah, you should say.
I
Yes.
just would like, my name's Maura, I
Hi,
would
Maura.
just like to ask what happens when the executive branch, who is supposed to be the enforcer of
An implementer, yeah.
an implementer, is the violator?
Good, I was gonna ask that. It's a great question. Boy, again, I don't want to get too scholarly, but I'm going to, you've heard of what I'm about to say, and I'm not sure if you know. How many people know what Marbury versus Madison is? How many people have heard of Marbury versus Madison? Okay. I love this case. I'm sorry, but I'll try to make it less dry, because it's not dry. It is now the first Supreme Court of the United States, and has this guy, 5 members, Justice John Marshall. It's a nascent It's an infant government that is so fragile that it's like that first infant who's still walking with furniture and, trying to learn how to walk. That's who we are. And Justice Marshall, Chief Justice Marshall, John Marshall, knew in Marbury versus Madison, for those of you who are plugging it into your phone, what happened was when they changed the administration between John Adams, our second president, and Thomas Jefferson, our third president, Madison, the Madisonian model of the three branches of government that we're talking about, and the Federalist Papers, believed in a big, strong, he was Secretary of State, and a new fellow by the name of Marbury was coming in to be Secretary of State, and John Adams appointed the Secretary of, no it wasn't, it was Justice of the Peace, whatever it was. He appointed somebody on the way out, it was like a midnight appointment on the way out. And the question for the court was whether the new president was bound by the decisions of the former president or not. To make a very long and complicated story short, Justice Marshall realized, for the reasons we were talking about before, the judiciary, the third branch, is very vulnerable. It doesn't control the money, Congress does. It doesn't have guns, the executive branch does. If he infuriates the new incoming president, Jefferson, then he's doomed, right? But at the same time, he felt that there were certain rights. So this is what he did. And he writes this. He says, under our system of government, the legislature makes the laws, the executive branch enforces and implements the laws, and the judiciary interprets the laws. This is the first time we're asked to invalidate the actions of, let's call them either Congress or the executive branch. And he dubbed it judicial review. And what he said in 1803, which still rules to this day, is it's that third branch that can tell the second branch or the first branch, you may not do what you've done. That's unconstitutional. That's our job to determine whether you can do it or not. Which I mentioned in the Religious Freedom Restoration Act. The court said, you can't do that, that's our job to determine that, whether the Constitution allows that. It's not your job to interpret the Constitution. So, since then, there's been this constant question of whether or not government, Congress, is unduly making a law that conflicts with the Constitution, or the executive branch is doing something that conflicts with the Constitution, separating families, separating children from their parents at the border. You executive, you're not allowed to do that, said the court to the Justice Department, which is in charge of immigration policy, right? The court said, we can tell you, you may not do that, and you have until this date, or. So judicial review is the third branch talking to the other two and saying, you've exceeded your authority under the Constitution, right? And as we're seeing here, my thesis today is that it's being abused because the Supreme Court of the United States has weaponized the First Amendment in order to achieve a political agenda instead of celebrate the rule of law and protect the rule of law. And that's my thesis, and I think I have to end with that. But you guys, and you two should have at it.
All of our productions at GCTV are sponsored in part by Bay State Health, providing the care you and your family need when you need it, close to home. Visit them online at baystatehealth.org. Greenfield Savings Bank. Visit them at 400 Main Street in Greenfield. Call them at 774-3191 or go online to greenfieldsavings.com. Greenfield Community College, providing access and excellence in higher education in the Pioneer Valley. Visit them at gcc.mass.edu. The Hammond Family. The Hammond family are longtime supporters of Greenfield Community Television. New Fortune Chinese Restaurant on the Mohawk Trail in Greenfield. Visit them online at newfortunema.com. Call them at 772-0838 and check them out on Facebook. Real Cleaning Services, cleaning Hampshire and Franklin County since 1972. We don't cut corners, we clean them. Check them out online at realclean.com. Call them at 413-422-1143. People's United Bank, located at 45 Federal Street in Greenfield. You can call them at 774-3713 or visit them online at peoples.com. The Solar Store of Greenfield, replacing fossil fuels and nuclear power one home at a time. Visit them at 23 Fisk Ave. Call them at 413-772-3122 or visit them online at solarstoreofgreenfield.com. Thank you to our sponsors for supporting all of GCTV's productions.